Good afternoon. This is House Judiciary Committee. It is March the 27th, and we're going to go ahead and get started. Let's see, Delegate Kelly. Oh, it's actually a former delegate, soon not to be a senator. That's fine. We'll go with this Senate Bill 905, and then I think I just saw Senator Carter come in and others. So
excellent.
Please, Senator Kelly.
Thank you so much. Thank you, Mr. Chairman, Madam Vice Chair, members of this committee. I'm so excited to be here. So this is Senate Bill 905, which is a cross-file of House Bill 1267, which you all voted out. It does have an amendment on it that the Senate put on. So I'm going to just discuss with you two things. One is the Senate amendment, and one is another technical tweak that we've identified needs to happen. So the Senate amendment, which was developed in conjunction with the advocates and Senator James and Senator Folden, requires the judiciary to require that this is the bill that has to do with public health access to the ERPOs. So it requires the judiciary to create an agreement to provide for the storage and handling of the records and establishing the penalties associated with that. Basically, that amendment was how should I put this diplomatically? I had a conversation with the House sponsor of the bill. She had indicated earlier to your council that she would like to resist this amendment. However, upon further consultation today with the House sponsor and the advocates, we've determined that because of the Senate posture on this bill, the strongest bill we're going to get out is with this amendment. So she would like the House bill to have this amendment as well as the Senate bill. Again, it's in the committee's decision making, and I trust your judgment on this. But my ask to you is for you to accept the Senate amendment so that we can have a bill this year. I think the advocates are comfortable with this amendment. The language was worked out with the chair of JPR, the advocates, and the senators that I mentioned. And I am concerned that if we don't have this amendment, we would end up with no bill. So that is my concern. But I trust your judgment on what you choose to do and how you choose to deal with the communications between the committees. The one thing I will note to you is that should you move forward with the Senate amendment, there's a technical change that needs to happen in the purpose paragraph because the Senate, in its wisdom, went through multiple iterations of this amendment. There was a little bit of language related to penalties left in the purpose paragraph that needs to be stricken. So it says in the purpose paragraph of the Senate bill as amended, there's language regarding establishing penalties that actually shouldn't be there because there's no penalties in the amendment. So it's just the three words establishing certain penalties. We would recommend that that be stricken because it's just, as you can see in the language of the amended language, that the judiciary may institute an injunction or any other appropriate remedy, but there's no penalties in the language. I hope that is clear.
Questions? All right. Seeing none, we thank you very much. That concludes the testimony on Senate Bill 905.
Thank you.
Thank you very much. Who did I see? I thought Senator Carter. All right, I see Senator Carter, Senator Simonaire. Am I missing somebody? Not yet. Senator Carter, please, on 452.
Good afternoon, Mr. Chair and committee. It's nice to be back. I missed you yesterday, Mr. Chair. I hope all is well. So you've heard this bill before. You've passed this bill before. You've passed this bill 2 times. This is a really good government bill and a bill that is really beneficial to our constituents. I don't need to go into the details. I don't think this is the bill that prohibits liability waivers for negligence at recreational facilities. I believe that House Bill 162, Delegate Cardin's bill, was passed clean by this body. The Senate did decide to make an exclusion and exclude certain lodging facilities. There was an amendment put on the Senate. I'm frankly going to leave it up to this committee to make a decision as to what we need to do. But after 2 years, I would urge us to do something. And for those that have concerns, because I've seen the emails coming in, you know, each year it seems to be that we finish with bill hearings, we finish with voting sessions, and then some entity comes in and says, hey, this is going to be bad for us. I would urge us to resist that because that is why we have public bill hearings. And I believe that from all that I've read, there's this anticipatory problem. But here's the deal. Businesses are not supposed to be negligent. And when they are negligent and they create a harm to someone, they are supposed to be liable for it. And under law, that person that's been harmed by the negligence of a business is supposed to be entitled to collect damages. And that's all this bill ensures that is done. It ensures that a business cannot indemnify itself from its own negligence. I'm happy to take questions. Thank you.
Thank you, Mr. Chair. So how did the Senate amend it? I'm reading the bill. Can you clarify it for me? Who did they exempt?
It was really designed at hotels, particularly the Marriott hotel chain was particularly
The one that got the tax credit?
unhappy with it. And so it labels it as lodging facilities that do not own recreational facilities.
But they would potentially have a gym.
Yes, they could.
Who else?
That was, I believe, all that we exempted in the Senate, the lodging facilities.
All right, thank you.
Yes, Senator Carter, good to see you. It's been nice. I've gotten to see you every day this week. My question, but my question is this. I agree with you. The opponents are kind of late to the party, but I've been getting a lot of emails. But isn't it true, you sort of articulated it, but isn't it true that the Senate already made some concessions to the business community in an attempt to address their concerns, given that 2 amendments were tacked on?
It's true. And again, I think that it's important that we, but I don't particularly agree that it was necessary to do that either. But you know, I had no choice.
Well, you're a kind person. What can I say?
Delegate Williams.
Thank you, Mr. Chair, and thank you, Senator Carter, for being here. You sort of answered my first question with your opinion about the amendments. And I guess I'm just trying to understand kind of the why of the amendments, if you know kind of why there was folks felt the need to exempt the lodging establishment as well as the health club services.
They wanted to limit it for health club services for adults, so that we were only really making sure that a child would be covered. I don't think that makes a lot of logical sense. But again, I'm not criticizing the Senate bill. I'm simply saying you passed a clean bill, and I'm going to leave it up to this committee to decide, you know, which version you want to go along with. I think the clean bill is fine. And I want to make it clear, you know, these businesses seem to come up with all kinds of anticipatory problems that have not occurred. And they should not be able to indemnify themselves against negligence. You know, if someone does a really risky, unorthodox jump on a trampoline, then that would not be covered. But if the business failed to maintain the trampoline, if there were rusty springs in the trampoline, then it would be, and it should be. And that's all this bill does, is ensures that they are not indemnified for negligence that causes harm to people that we represent.
Thank you.
Thank you. Hi, Senator. How are you?
I'm good, thank you.
Good. I wanted to ask you a quick question about whether or not the bill, you touched on it with the children part on the amendment. Does the bill deal with just plain as amended, simple negligence in the sense that you breach a standard, that, you know, there's causation and damages? Is it simple negligence, or is it a form of gross negligence in the bill?
No, I believe it, my understanding is it's just plain negligence.
Just plain negligence. Okay. And so you were talking about the children. Can you tell me, because that's actually something I was concerned about. Is the thought that in the amendment that excluding the you know, mentioning some of these health club services and excluding the lodging, is that meant to is that as far as it goes with respect to the children? In the sense that, like, I'm receiving a lot of emails too, as I'm sure we all are. Some of the water parks and things of that sort, those would still remain in the bill if it's not connected to a lodging facility.
Correct.
Okay. I think I understand it better now. Thank you.
Thank you.
Delegate Toll.
Thank you, Mr. Chair. So, Madam Vice Chair answered my first question, which was the facilities with the attached to the amusement parks. So my second question is, how was this bill passed last year?
So-
Was it passed with these?
Last year, I believe this committee passed the bill clean.
That's what I thought as well. I thought it was clean. It was not with, thank you.
Right, and I think this bill got held up and it was really sine die, probably about to go through, and I think whatever happened, it missed. So now, again, now here we are, second year, going through it again, and lots of entities jumping on and saying, hey, we want to be excluded.
Mhm.
If anyone wanted my opinion, I would ask that we would vote the bill clean or as clean as possible. And if these businesses actually have a problem with them, come back another year with a bill, hold a full hearing really quickly. I won't be long, but Delegate Embry and I just experienced this with our security guard bill, where the hospitals at the 11th hour wanted to be excluded. We said, no, the bill's gone through. They came back this year with a new bill and we listened to it and we passed their bill. So it's not unheard of that we can make an exemption, but I just think there should be a full public hearing on it.
Mhm. Agreed. Thank you.
Thank you, Chair, and thank you, Senator, for being here. Quick question on the amendments. Does it narrow the scope of the definition of a recreational facility, or does it bring the bill more in line on the amendments here versus lodging establishment? Does it just narrow it down a little bit from the Senate amendment?
So it still covers recreational facilities. It simply excludes a lodging facility.
Excludes it. Okay, I understand now. All right, thank you.
Thank you. I'd urge a favorable report. Or conform it to the House bill if you'd like.
That's,
The option.
that concludes Senate Bill 452. Thank you
Thank
very
you.
much, Senator Carter. We're going to go to Senator Simonaire, please. And Senate Bill 585.
I need to push. That's the same rule in the Senate, but it wasn't going red for a little bit. For the record, Senator Simonaire here on Senate Bill 585, hit and run penalties associated with the Maryland State Boating Act. Senate Bill 585 is a consensus bill, and I want to thank DNR and the state's attorneys across the state for their support. We were told this bill was only a sponsor only, so I would have you reference the Anne Arundel County State's Attorney's Office written testimony as they lay out a very clear, concise, and compelling argument for this legislation. I served 4 years on JPR, so I appreciate all the work you all are doing here. Since then, I've served on the newly minted Education, Energy, and Environment Committee. As you know, the Natural Resources Maryland State Boat Act was enacted in 1960 and has been updated ever since. This bill simply adds language and penalties for hit and run that occur on the water that mirrors the penalties we have in the transportation article. For a boat operator currently involved in an accident, there is a duty to render assistance and provide information. It should be noted, though, there is no specific penalty for not rendering assistance or by extension, leaving the scene. So it falls under the Natural Resources article catch-all penalty provision that provides a maximum penalty of a $500 citation. Additionally, there is no penalty for hit and run as it pertains to a person knowing it might have resulted in serious bodily injury or death, as in the transportation article for vehicles on the roadways, which rightly so carries a higher penalty. In the Natural Resources, a hit and run that knowingly causes death receives a maximum of only $500 and no jail time. In the transportation article for the same crime, receives a maximum of $10,000 and 10 years in jail. This bill creates parity and equity with vehicles and vessels regarding hit and run by mirroring the transportation article for the natural resources article. Additionally, we incorporated DNR's request to add the condition of the boat's navigational lights when following a boating accident report. One of my constituents personally experienced the lack of meaningful penalties for the hit and run incidents on our waterways. A couple was out on the water when a boat rammed them and came up on their stern. The boat pinned his wife on the port side seat. When he miraculously pushed the boat off of his wife, he said he was going to contact the police, at which point the other boat fled the scene. Others eventually came over and helped and took him to a marina where she passed away. The greatest penalty for the boating hit and run portion of this accident was a $500 citation. While this bill will not affect my constituent, it will be very meaningful to those in the. I would ask for your favorable consideration.
All right, seeing none, thank you very much, Senator. That
Thank you.
concludes the testimony on Senate Bill 585. We'll now go to two bills, Senator Waldstreicher, starting with Senate Bill 468. Or I'm sorry, 488, I beg your pardon.
Thank you, Mr. Chairman, Madam Vice Chair. In 2005, Congress passed a law called PLCA. In essence, PLCA did two things. First, PLCA provided complete legal immunity to the gun industry in federal courts. Second, PLCA provided complete legal immunity to the gun industry in state courts unless the state passes a law saying otherwise. Senate Bill 488, the Gun Industry Accountability Act of 2024, is Maryland saying otherwise. Let's pause there for a second and linger on how strange PLCA is. Under federal law, the firearm industry is the only industry in the nation's history to receive complete immunity from lawsuits. The tobacco industry never received immunity from lawsuits. The pharmaceutical industry never received immunity from lawsuits. The auto industry never received immunity from lawsuits. And so Senate Bill 488 isn't a significant change in policy. It simply places one industry in the same position as every other industry. It means that when it comes to the Attorney General, the gun industry is similarly situated to the tobacco industry, to the pharmaceutical industry, or the auto industry. The only industry players that need to worry after their immunity is lifted are bad actors. In the tobacco industry, manufacturers publicly stated that their product wasn't addictive and destroyed documents that said otherwise. Those bad actors were subject to our tort system. In the pharmaceutical industry, the manufacturer of OxyContin, Purdue, lacked reasonable controls to prevent their pills from ending up in the illicit market and sold their products to doctors who they knew were running pill mills. Purdue was a bad actor and subject to our tort system. In the auto industry, Ford in the 1970s made a model called the Pinto, which had the gas tank in the back. When struck from behind, some exploded. In an internal memo, Ford indicated that they knew of the issue, but declined to install an $11 solution. Ford was a bad actor and subject to our tort system. It might surprise you to learn that I don't believe that most gun industry players are bad actors. But if you knowingly market guns to children, if you knowingly sell a product that can be illegally modified into an automatic weapon, if you knowingly fail to exercise institutional controls such that your product ends up in the hands of criminals, then you are a bad actor. Mr. Chairman, this bill is now substantially more limited and narrow than the bill you originally heard. The right of action belongs solely to the Attorney General in the amended bill. The private right of action was completely eliminated, especially now that the bill has been substantially slimmed down and is quite narrow in scope. If you are a good actor in the industry, you have nothing to worry about. But because there are bad actors in every industry, we need to pass Senate Bill 488. Thank you, Mr. Chairman.
Thank you, Mr. Chair. Good to see you,
Good
Senator.
to see you.
I know we don't always agree on this issue. Is driving a Pinto a constitutionally protected right?
So I'm happy to answer that question. So there is no question that owning a firearm is a constitutional right. But that is not relevant to our discussion. Constitutional rights are subscribed all the time based on reasonableness. If there was a protest held in the House chamber, that would be unreasonable and we disallow it. If there was a protest at 3 a.m. in your neighborhood using microphones, we would disallow it. And that would be constitutional. And so the fact that a Second Amendment right is implicated in this bill is not relevant to the discussion here today. Constitutional rights are circumscribed based on the concept of reasonableness all the time.
Okay. Is there a mid to late 1700s analog you can point to that will make this constitutional?
So this case doesn't implicate the Bruin case.
Mhm.
The Bruin case requires a historical analog for determining how and where guns can be brought. This bill does not implicate how and where guns can be utilized in public society.
Has it been litigated?
This case, these laws have been passed in 8 other states. They are actively being litigated.
Okay,
In
so we don't have a
In
ruling.
0 states has a court struck this law down based on Bruin.
Right,
fact,
based on Bruin.
in
Any other
0
cases?
In 0 cases has this bill been struck down in any other state at all. It remains in active litigation.
Okay, so it's not made its way to SCOTUS yet, and you're anticipating that once it gets there, it's not going to have a similar requirement that Bruin had?
I think that's right. In fact, in June, in an unrelated case with which many of you are familiar, I think you'll see the Supreme Court walking back portions of the Bruin decision.
In the upcoming, this June, you're predicting in this June, we'll see that?
Not on this case, on an unrelated matter, on the domestic violence case that many of you are familiar with.
What is it?
What's the name? I'm not sure, I don't have the name of the case in front of me.
Okay, okay, all right. I appreciate your answering my questions.
Of course.
Thank you, Mr. Chairman. Thank you, Senator, for coming in. Are you saying that the Glock or the manufacturer of Glocks is a bad actor because their item can be easily modified, made fully automatic?
The answer is yes. Let me kind of speak to this Glock issue with which many of you are familiar. JPR heard the speaker's bill yesterday, and we will pass it within the next 48 hours, I imagine. It's an important bill, and her bill is exclusively criminal. This bill is exclusively civil. They would complement each other and work together in harmony. The ability to modify Glocks with $30 switches that turn them into automatic weapons is terrifying and shows why this bill is so critical. And let me do this once more through analogy. We spoke about the auto industry earlier. The car companies Hyundai and Kia made vehicles with key fobs that are easily copied. How to make that copy is quickly available on YouTube or TikTok. This has led to an exponential increase in thefts of Kias and Hyundais. Some of you own Kias and Hyundais and are worrying about this or have installed a club on your steering wheel to deal with it. Others of you are prosecutors and have interfaced with criminals who have stolen Kias and Hyundais using this technique. A lawsuit was brought against Kia and Hyundai. And you know what the first thing to happen after that lawsuit was? Kia and Hyundai swiftly modified their design. If you purchase a Kia or a Hyundai, right now, your key and your car are safe. Now contrast Glock. Glock designed a weapon that can easily and illegally be modified to turn into a fully automatic weapon. But because they are protected by PLCA, there is no incentive for Glock to modify their design to prevent the $30 switch from being installed. If you were to legally purchase a Glock right now, even after they have clear and actual knowledge that their gun can be illegally modified and bring terror to our streets, that Glock would still have the ability to be modified if you bought it today, after they know about this. And so, Mr. Chairman, I know you're very familiar with this. I know Delegate Simmons has also been helpful with the Brooklyn issue. In the Brooklyn case, a Glock was modified into an automatic weapon. Glock knows what has happened and has made no change. This is a perfect example as to why we need the legislation in front of us.
Delegate Grammer, then Embry.
Thank you, Mr. Chair. I appreciate you being here. I have some concerns about the bill. You mentioned the bill SB1 last year. We talked about it. You said it was unconstitutional. That got blown up pretty quickly. So the analogies that we're making today, it's Kia's fault that they made this car that was easily hackable, but there's a bug in every piece of software, piece of electronic equipment that's been designed for the last ever. And it's a bit of a false analogy to say, well, because someone else could modify this product, it's the fault of the manufacturer. that they made it so easily, the product so easily alterable. And frankly, that gun's not the only gun you could do that with. So my real problem with this bill, I think, revolves around this particular language. A party seeking relief under this section is not required to prove that a firearm industry member acted with the intent to violate the subtitle. You're kind of creating a cause of action where they're not even required to prove that there's an intent to violate any law. And this bill is written so broadly that it can create a mechanism just to bludgeon the hell out of any legitimate actor, even though it's not their fault, even though they maybe made an affordable car that unintentionally provided a mechanism to be ripped apart and hacked. So if we were to do this with any industry, what kind of precedent are we setting where even though it's not their intention, even though they didn't make a product with the intent, that we're going to have this giant bat, which frankly you could probably chase them out of the state with? Is there any kind of precedent for that at all?
So respectfully, Delegate, I don't believe your legal analysis here is correct. The statement at the end of the bill that you don't have to have knowledge that you are violating the law in order to be sued under the provision is traditional boilerplate that is consistent with how criminal law, for example, works every time. And so you have to, under criminal law, you have to have an intent to commit the act, but you don't have to have an intent to violate the law. And there's a distinction there that's important. If I were to go 85 miles per hour on Route 50 and got pulled over for speeding, the prosecutor would have to prove that I had the intent to go 85 miles per hour. But the prosecutor would not have to prove that I have knowledge that 85 miles per hour is over the speed limit. That's, in its reduced form, that's saying ignorance of law is not an excuse to violate it. The bill does have an intent requirement. To say otherwise is incorrect. The bill requires that the act be done knowingly. That's on page 3, line 23. This is not a strict liability bill. And in the House hearing, some people kind of threw that out there in the hopes that it would stick. Black's Law Dictionary defines strict liability as the plaintiff's ability to receive compensation without having to prove how or why the harm occurred. This bill does nothing of the sort. Instead, the legislation explicitly relies on traditional tort theory. In tort, 4 elements are always required. 1, a duty of care. 2, a breach of that duty. 3, causation. And 4, damages. That's what the Attorney General would need to prove in each and every case brought under this section. The gun industry has a duty to act lawfully and reasonably. They can be held liable if they knowingly breach that duty, meaning there's an explicit mens rea requirement, and only if the Attorney General can prove that the breach of duty caused real damages, meaning there's a clear nexus between the act and the harm.
Generally, in terms of what you've said here, but you can also write a bill that's so broad. I mean, the part of the bill that you're mentioning, firearm industry member may not knowingly create, maintain, contribute to harm the public through the sale, manufacture, distribution, importation, or marketing. I mean, we're talking about the way that you depict a product, and now they could be found culpable for finding for something that's generally unreasonable under the totality of the circumstances. I mean, that's such a broad.
Is this the marketing to which you refer?
I'm reading the bill.
So here's an advertisement for a JR-15. Get them one like yours, smaller, safer, lighter. Our goal was to develop a shooting platform that was not only sized correctly and safe, but also looks, feels, and operates just like mom and dad's gun. Is this the marketing material to which you refer?
I don't know what that gun is or what you're looking at, but I think it kind of shows like the ridiculousness of it. Like, I own firearms. If I don't carry personally, but if I did, I'd want something that was light and et cetera.
Well, on this, you and I can agree. This advertising is definitely ridiculous.
Well, I think the way you're depicting this so broadly to encapsulate even the way you market a product that you may be able to destroy an industry is a pretty clear indicator about the intent of the bill. But I appreciate you answering our questions.
Thank you for being here. Thank you for bringing the bill, and thank you also to Delegate Phillips. So as amended, the bill would not allow local jurisdictions to bring suit under this statute. And of course, jurisdictions like Baltimore City that are disproportionately impacted by gun violence would have an interest, I think, in doing so. I just wonder if you considered that on the Senate side, and if you could comment on the reason for not including localities.
So it's a really good question. And the answer is yes. To the extent that this committee would seek to add the county attorneys and the Baltimore City Solicitor to the right of action under this bill, I think that that is something the Senate could accept. And here's why. We struck the private right of action, substantially narrowing the bill specifically to avoid the perception of a legal free-for-all or that there might be frivolous lawsuits. We kept the Attorney General because we know that office focuses on meritorious litigation that can win in court and have a real impact in deterring bad actors. The county attorneys and the Baltimore City Solicitor fit that same description. In a world of limited resources, they only bring meritorious cases that they believe they can win.
Delegate Conaway, second bite.
Thank you, Mr. Chairman. Thank you again, Senator, for coming in. I just want to be clear on this. We talked about the Glock and that being able to be modified. So in the case of, let's say, a pump, I think you call it pump shotgun, a lot of times they'll have a barrel that if you remove what's called a stick or the plug, you can put 5 cartridges in the barrel instead of 3, which would be illegal, but you can modify it by taking the stick out. So should those type of shotguns be included with this type of legislation?
So I don't know the answer to that question because I'm not familiar enough with the weapon to which you refer, but I would say this. The bill is built around the concept of reasonableness, which is the same concept that undergirds the entire tort system. And so the Attorney General, the Office of the Attorney General is intimately familiar with the concept of reasonableness. Gun industry defense attorneys are intimately familiar with the concept of reasonableness. Judges every day make determinations in our tort system as to the reasonableness of certain behavior. And so these are highly fact-specific cases, and judges, the Attorney General, and defense attorneys utilize the standard under which this bill operates each and every day and would be able to make the determination that you indicate.
Thank you, Senator.
Thank you, Mr. Chair and Mr. Vice Chair, and thank you for bringing this bill. And it's been really my honor to kind of work on this with you. Given our current state, how do you think this will play out ultimately once it is passed? Folks are concerned that there will be this significant litigation. By limiting the plaintiff to 1 or maybe 25, how would you see this really playing out? And how would it operate as a true deterrent to perhaps improve the industry?
Well, thank you, Delegate Phillips, and thank you for your hard work on this bill. And I know how much time and effort you've put into this with the advocates. I think the answer to the question is this would play out with modesty and judiciousness. The Attorney General, when he testified in front of the Judicial Proceedings Committee, and I think when he testified here, said to us that he intends to hire no new people to implement this legislation and does not intend to open a separate office to effectuate the intent of this litigation. The Office of the Attorney General regularly brings civil suits against bad actors in industries across this state. The gun industry would simply be added to the mix of other industries that could be held accountable in our tort system. And so I don't think the Attorney General intends to utilize this in any way different from the way he brings suit in other matters. But it will, what it will do, in answer to the second portion of your question, is provide the correct incentives for industry to change where they are but where there are bad actors. Again, I actually don't think most folks in the gun industry are bad actors. And I think those good actors, who are the ones who sometimes appear before us, won't be impacted by this bill. The bad actors don't come and testify in front of Judiciary. The bad actors don't come and testify in front of JPR, but they're scared of this bill, and rightly so, because civil tort liability will provide accountability for them.
Chair.
Thank you, Mr. Chair, and thank you, Mr. Vice Chair, for being here. I wanted to ask you, what is the public policy behind this bill?
So, I don't mean to repeat myself, thank you, Vice Chair, but the public policy is that we have 3 legs to the stool in which we hold bad actors accountable. We have criminal law, we have administrative regulations, and we have tort liability. All 3 of these legs work in concert to incentivize good behavior and disincentivize bad acts. The gun industry is the only industry in which only 2 of the 3 legs of the stool exist. And so, yes, the gun industry is highly regulated. Yes, the gun industry is subject to a tremendous amount of administrative regulation. That's a good thing. But that's also an argument for the bill, not against the bill, because it's missing the 3rd leg of the stool. It's missing the tort accountability that held the pharmaceutical industry accountable, that held the auto industry accountable, that held the tobacco industry accountable. That's why we need Senate Bill 488.
And so, you were stating in a regular tort case, so the standard that these industry members would be held against would be, how would that standard be kind of laid out as far, just in general?
Yeah, well, it's laid out in the words of the bill to provide predictability to both the Attorney General and the industry. At its core, it is a reasonableness standard. And again, this is the standard by which plaintiffs, defendants, and the Attorney General and judges operate on a daily basis in our tort system. And that is the core of the bill.
I know I'm interrupting you, but is it just what is reasonable to you and what is reasonable to me?
Sure.
Or is it just, or is the reasonableness of the industry itself?
Sure, that's an important question. In our tort system, reasonableness is always an objective standard. It is never a subjective standard. That is the way that the reasonableness standard works in the tort system. This bill changes that not at all. And so the standard would remain an objective standard.
And my last question, Mr. Chair, is what would be some of the damages? I don't know if I asked that. If I didn't, I wanted to ask that. What would be some of the damages that the Attorney General's office would claim? And are they making that claim on behalf of citizens as a whole, society as a whole, or just how would that work?
That's a good question. So page 4, lines 11 through 17 of the amended bill provide the relief that the Attorney General can seek in these matters. And he or she would do so on behalf of the people of Maryland. And so they may seek injunctive relief, restitution, compensatory and punitive damages, reasonable attorney's fees and costs, and any other appropriate relief.
All right, seeing no further questions, that concludes the testimony on Senate Bill 488. Go now to Senate Bill 538, please.
Thank you, Mr. Chairman. More torts. Senate Bill 538 increases the government-imposed amount on non-economic damages. What are non-economic damages? The best place to start is actually the revised fiscal note. At the top of page 2, non-economic damages are defined in very human terms. Non-economic damages is pain. I want you to think of the worst pain you've ever experienced. The feelings you felt, the way your body reacted. Pain can reach levels you never thought imaginable. Non-economic damages is pain. Non-economic damages is suffering. How is suffering different than pain? Because suffering is longitudinal. Suffering is exhaustion. Suffering eats slowly at your soul. Non-economic damages is suffering. Non-economic damages is disfigurement. Imagine losing a hand or a leg. Imagine burns across your body. Imagine looking at yourself in the mirror and not recognizing the person looking back. Disfigurement isn't just about loss of function. Disfigurement is about the loss of self. Non-economic damages is disfigurement. Non-economic damages is loss of consortium, which is just a euphemism for loss of sexual function. Injuries often eliminate the ability to be intimate. Think of how this might impact someone's perception of meaning in a relationship, how it impacts the sacred bonds of marriage. Non-economic damages is loss of consortium. And so you have two sides of the ledger. On one side are economic damages, your medical bills, maybe lost wages. And on the other side of the ledger is the pain you feel, the suffering you endure, the disfigurement you see each and every day, the loss of marital intimacy. And I want you to ask yourself, which side of the ledger is more important to you? And if it's the latter, and I'm guessing for most of you here, it's the latter, ask yourself why it's that side of the ledger where the current cap is so restrictive. SB 538 fixes this. It simply allows our constituents to recover more on the more important side of the ledger. I ask for a favorable report.
I haven't.
You, Mr. Chair, can you talk a little bit about the impact of this type of legislation when it comes to insurance carriers and the industry and in whole?
That's a great question. And the best place to start is the industry itself. And so I brought with me something I'm happy to email to you. It's called Auto Insurance, The Uncertain Road Ahead. And it's published by some folks who are here today who oppose the bill, the American Property Casualty Insurance Association, and it's from June, not that long ago. And it talks about the increasing cost of auto insurance and indicates why that is happening. So here's what the auto industry says is why insurance rates go up. Number one, the frequency and severity of claims. That's pretty obvious, but how often people get in accidents and the severity of the accidents is the primary driver of insurance costs. Number two, shifts in driving habits, deterioration in driving behavior. The number two reason insurance rates are going up, according to the industry itself, the people who have come to testify against this bill, is not non-economic damages, but driver behavior. And you see this every day driving to Annapolis. People are more rude on the road and are driving terribly. That is increasing the cost of insurance. Then the insurance industry goes on to identify a third reason costs are going up. And it says injury claim settlements. So there it is. The third is lawsuits. But when you look at the report and you say, hey, is it the non-economic damages that they're referring to? It is not. The next goes to show a chart related to bodily injury liability. Bodily injury, the economic damages, which are uncapped in current law, and this bill doesn't change it. And so the insurance industry itself is saying non-economic damages does not impact insurance prices and identifies three unrelated reasons in its own publication about why rates are going up. So the answer is no, this bill will not implicate insurance rates.
Thank you. And if it's okay, can I have a couple? I appreciate it. The first thing is, I had a visit from the Maryland Hospital Association the other day, and I always enjoy seeing them, but they're opposed to this bill, and I was puzzled as to why, because did I read it correctly or could have missed it? This bill does not impact malpractice. Is that correct?
That is exactly correct.
Secondly, liberal bastions such as Oklahoma, Louisiana, Texas, and Alabama have no caps. This just raises the caps. but have you seen that their rates have gone through the roof? Because I think there's been a lot of metaphorical bedwetting on this matter, and I was just wondering if you've actually seen some facts that indicate that it goes up.
We do have facts, but not the facts that they go up. Let me just give a quick cite for on your first question. Medical malpractice is not implicated in this bill whatsoever. Medical malpractice falls under Title III, subsection 2A. This bill does not touch that subsection. This bill only affects section 11-108. And so medical malpractice is not impacted. To the second question, there is no relationship between insurance costs and caps. We talked about that a second ago, but here's some data that shows that there is no causation. So I have a list of insurance costs by state, 1 through 50. Maryland has the 18th most insurance costs for auto. The #1 state, the most expensive state on this list is Florida. They have no caps. And you're like, oh, well, that proves the insurance side right. The cheapest state is Vermont. They also have no caps. In other words, the #1 most expensive state, no caps. The number 50 most expensive state, no caps. There is no relationship between the caps and the prices.
And then finally, very briefly, Mr. Chair, aren't there other ways for insurance companies to limit their liability, such as a high-low where they can, if they get sued, they can say, okay, well, if you win, you'll agree to only get, I don't know, $1 million. And if you lose, we'll still pay you 500,000. So aren't there other ways to limit liability?
Yes, absolutely.
Thank you, thank you, Mr. Chairman. Good to see you, Senator. Did you get a chance to see the letter from MDOT or the fiscal note and how this bill will affect and potentially cost MDOT or MTA in particular a good amount of money? They're concerned because they do get a number of claims, and I was looking, I'm on the Board of Public Works website, and I'm looking at a contract that was put in place, and they mentioned at least a couple of years ago that on any given year they get about 8,000 claims, because obviously with the MTA, when you got a lot of buses out on tight roads in Baltimore City, it's bound to happen. Accidents are bound to happen. So have you had any conversations with the folks from MDOT and how this potentially could hurt the agency?
So really good question. So MTA is not subject to the Maryland Tort Claims Act. They're in a separate section. I don't doubt the number that you provided, that there are 8,000 claims against MTA, but they also provide separate data in the original fiscal note as to how many claims go over the $450,000. So, and this raises the cap to 1.75. And so the number of claims that have gone over 475,000 in the last 8 years, there were only 12 claims. So it's actually a very small amount of claims. So 12 out of 8,000 touch a $450,000 level. So let's imagine that there are about, let's just say 8 of those were above what this is saying, 1.75 million. And so the number of claims that this would impact is exceedingly tiny. And so in aggregate, the cost to MTA would be very small as well. Again, they wrote that to the original fiscal note, which in the original bill, there were no caps at all. The bill lifted the caps. This maintains the caps. It just raises it to a slightly higher level.
Thank you, sir. I just wanted to clarify, bodily injury, is that just considered economic damages, or is it both bodily injuries can fall under both economic and non-economic?
It is both.
It is both.
Well, I mean, it depends on the context in which you're talking about it. So in, I think the House hearing, there was testimony about someone who was injured and had a hysterectomy. She had her uterus removed in an injury. And so that's a bodily injury. The cost of that surgery is an economic damage. It'd be covered. The time off of work where she lost income because of the hysterectomy is economic damages. That would be covered. The impact on her life for the rest of her life about having children, about how she perceives herself with no uterus, that is not an economic damage. That is a non-economic damage. That's the part we cap. And so that's why I testified earlier that the things that make life worth living, that's the part that we're capping. And that's the part that doesn't make sense to me and why we're moving incrementally in the right direction by increasing that cap.
Thank you, Senator.
Thank you.
Thank you. Thank you, Mr. Chair, and thank you, Vice Chair, for being here today. When was the last time the cap was increased? I think we heard that the first time we heard this bill, but.
Yeah, that's right. So I heard 1994. That's correct.
Okay, 1994. And so a lot has changed since 1994. Since then, I guess my question is, what is the impact of the current cap amount, especially as it affects, you mentioned the woman who had the hysterectomy, for example, the effect that it has on, or the types of plaintiffs that are typically, trying to think of the best way to phrase this, that unfortunately are seeking these types of non-economic damages. I don't know if you have any statistics about how it may proportionally affect one demographic over another or anything along those lines.
So it's a really good question. So the non-economic damages cap raises serious equity issues. I recognize that I'm not the best messenger for equity arguments, but I don't need to be the messenger. This has been studied academically. And so I bring you, and I'd be happy to email 3 peer-reviewed law review articles that indicate that non-economic damages caps, or very low caps as Maryland has, disproportionately impact people of color and women. Here's why. Women, as you know, make 86 cents on the dollar. It's still Women's History Month, and I think we had Women's Pay Equity Day. And that's because of 2 reasons: a history of discrimination, and because women disproportionately stay home from the workforce to take care of children. And so imagine that in hypo form. A woman who has chosen to stay home to raise her children is severely injured. She can't get economic damages for lost wages. She has no wages. The only way she can recover is on the non-economic damages side. And that's the part that's capped. And that's why a low non-economic damages cap disproportionately impacts women. It also disproportionately impacts people of color. Why? Because of a history of discrimination, people of color make less income than people who look like me. And so if I was in an injury and a person of color were in an injury, and that person of color made less money than I did for any reason, including systemic discrimination, then our recovery in the case, even if the injuries were exactly the same, would be different because my economic damages would be higher. And so the only way to make up for that equity gap is in non-economic damages. But that's the part we cap. And so by raising the cap, we get closer and closer to more equitable system. So there's 3 definitive law articles on this. The one published here in Maryland is University of Baltimore Law Forum, Maryland Tort Damages, a form of sex-based discrimination by Rebecca Korsak.
Well, question, Mr. Chair. Yes, and the second question I have, in the amended bill, I think you guys got to, was it 1.75 million? I guess I'm curious as to how you got to that amount.
So I think it was a work group, a conversation among members of the committee who wanted to get closer to a place that was more equitable and where women and people of color could increase their non-economic damages recovery, where we could increase the amount of recovery for the harms that really affect people's lives, lack of reproductive function, disfigurement and the like, without completely eliminating the caps, which I think the Judicial Proceedings Committee found to be a step too far. So this was kind of the consensus of the work group.
Thank you, Mr. Chair. So I was actually going down that route in terms of the amendments, Mr. Vice Chair, and it was no cap at all but a ceiling rather, but you put it down to 1.2, 1.4, 1.75.
1.75, I believe.
And going back to that point, did you get to that number based off, 30 years of keeping up with the cost of inflation? Did you tie it to the CPI? What more technically? in the
Good
technical
question.
sense?
So we looked at what the number would be if we had adjusted for inflation. But then we also took in kind of policy considerations and a desire for a more equitable recovery system. And so we combined both the kind of the math part of the problem as well as the policy part of the problem to come up with the final number.
Okay. And I had one other question, but I can't understand my handwriting, so I will just
I do
pass.
that all the time.
I think Delegate Williams asked my question, but then the answer kind of confused me a little bit. So let me just make sure I'm clear. To determine non-economic damages, it's based on income or not?
No, income determines economic damages.
Only.
Correct.
And then how are non-economic damages then calculated?
Non-economic damages are determined by a jury of your peers with guidance by the judge who provides jury instructions as to how to value that.
Yeah. And right now, the cap is at 1 point, but the JPR has come up with 1.75 as being the negotiating point instead of no longer having no cap in the bill.
That's exactly right.
Thank you.
Thank you, Mr. Chair, and thank you, Mr. Vice Chair, for being here today. Admittedly, I'm not that familiar with insurance and tort reform and things of that nature, but I did receive quite a bit of feedback from my constituencies. So I did have one question, but I wanted to start out with a couple of comments, just simply from some of the feedback that I received from different entities. And what drew my particular attention out of these 32 different organizations that oppose this legislation were the two Chamber of Commerces that represent the businesses in the two counties I represent. So not having a lot of background, I went ahead and I wrote a question and I sent it off to the Maryland Insurance Administration because I was curious, trying to learn more about this. So the simple question that I wrote was, I was concerned about this legislation and what impact it could have on the availability and costs of insurance for the business community and its consumers and my constituents. So while they stated that they could not give definitive answers on these topics, they did state a few things that I just wanted to relay. And one was that they would expect an adverse impact on both availability and affordability over time for insurance. And the second was that it should be expected to put an upward pressure on liability rates and to impact limits and availability for some liability coverages. So my question is, as a result of a cap being raised or eliminated, which is being raised, how would this not increase the cost of insurance and requiring consumers to purchase even more insurance to cover the potential higher loss? That would be my question.
It's a really good question. And we talked about some of the data that we showed earlier, where there is no relationship between caps and auto insurance rates. So just so you know, 10 states have a cap like us. None of our neighbors have a cap. No one in the Eastern Seaboard has a cap. And so 40 states operate with no cap. This bill, as you know, no longer eliminates the cap, it just increases it. In all of those 40 states, many of which you travel to and you rent a car there and you pay for your insurance there when you visit and rent a car, they have insurance just like they have here. There are businesses operating in all of 40 states. They have accessible and affordable insurance. And so there's just no evidence that the opponent's view of this is correct because there's no data to back it up, because 40 other states operate differently from us. Those are red states, very deep conservative Republican states. Those are blue states, very liberal Democratic states. They have no caps. They have insurance. They have affordable insurance. They have accessible insurance. Maryland is the outlier, not the other 40 states.
Thank you, Mr. Chair.
The last question.
Thank you, Chair. On states that have caps, where does Maryland currently rank?
So that's a really good question. I actually don't have that information in front of me. I believe it has among the higher caps,
Okay.
states, but we can get you that data.
Okay. And was there any discussion? I know we have the $15,000 escalator.
Mhm.
Was there any discussion on maybe just improving that a little bit to
Yeah,
maybe keep up?
and we
with-
haven't, yeah, I'm sorry to interrupt. I apologize.
Yeah, that's okay.
So the bill does do that. It increases from 15 to 20,000. So as was indicated before, from 1994 until this year, the current escalator did not keep up with inflation. And so to better mimic inflation, we also increased the escalator from 15 to $20,000.
And where, from 1994, you brought it up a few times, and some of the other questions I had were answered. 1994 to now, where would that put us in line with the inflation over that period of time?
I believe it would put us at $1.02 million.
Okay. All right. Thank you very much.
All right, thank you very much.
Thank you, Mr. Chairman.
The testimony on Senate Bill 538. And since you've now inconvenienced the chair of JPR enough, we'll now take Senator Smith. Senate Bill 1097, please. Senator Smith.
That's not the first
Mr.
time that's
Chairman?
happened, you know. Yeah.
Well, I can't imagine it is. I'm just saying.
I'm kidding. We love each other. It's great.
Okay.
I'm serious. No, but before, thank you, Mr. Chairman, and thank you all for having me. Before we get started, Mr. Chairman, I did want to just acknowledge what happened yesterday, that not only impacts all 6.2 million Marylanders and not only every American, but especially the folks that represent the city. So Delegate Embry, Delegate Conaway, and you, Mr. Chairman, I just wanted to say that we're all here for you. And I'm from Montgomery County, but just wanted to lend my thoughts and support to you. Senator Smith here to present Senate Bill 1097, and the former the old chairman of this committee, or I should say former, I guess both are true, used to had some guidance for us for legislation. One was that does your bill solve a problem? Does it solve a Maryland problem? Does it actually solve the Maryland problem? And what are the unintended consequences? And Mr. Chairman, I've departed a little bit for the Maryland centric piece of this for the initial idea. Over the summer, I became aware of what was happening across the country with gun buybacks. These are programs that are administered all throughout our state. And this piece of legislation doesn't make a judgment call as to whether those are good things or bad things. I happen to think that they can be productive. But what's happening is the federal definition of a firearm only includes the frame or the receiver and not the other component parts of the weapon, what you all think of in your mind's eye as the gun. And what's happening is that the gun buyback, the folks that are disposing of them, these companies that are doing this, are only disposing of the frame and the receiver, but then selling the rest of the component parts back into the stream of commerce. And so what this bill does, and we've done a lot of great work on ghost guns, and you understand that, I mean, with the proliferation and democratization of 3D printers, printing out the supplemental parts to create a completed firearm contributes to ghost guns in Maryland. So what this bill does is, the first part of it does is it says that, look, if you have a gun buyback program, you have to destroy every piece of that firearm. You have to obliterate it so that it's inoperable and it's gone. And so I'm going to walk you through the bill just very briefly, and then I'll take questions at the end, Mr. Chairman, because this is somewhat of a Christmas tree. So that's the basic premise of the bill, but then there are a couple other elements in here that that deal with firearms but are not directly related to gun buybacks. So if you go through if you have the interlineated third reader report from the Senate, there's a part from the Department of when we passed Senate Bill 1 last year, which created places where you could not carry your firearm. We left out a part for the Department of Natural Resources. They operate a police force. And sometimes they need to go into places to, let's say, put down a dangerous animal or something like that. We left that out, and so there is a piece here that puts them back in and says, hey, look, they can carry in some of these protected or exclusionary zones that we created with SB1 last year. So I view that as a technical fix, an oversight from last year, and the Department of Natural Resources asked that we find a place to put it. So I stuck it into this bill. I think that's fairly non-offensive, but that's another element on the Christmas tree. You follow down the next major component piece is that it says that a person that is convicted of a theft of a firearm then is now that's going to be a felony and not a misdemeanor. Possession of a stolen firearm is a misdemeanor, a 5-year misdemeanor. If you steal, theft is based on the value of the item. So anything above $1,500 is a felony, anything below misdemeanor. A firearm being an inherently dangerous item shouldn't be tagged to the price. Very few, if any, except the highly specialized handguns or like the regulated firearms cost anything close to $1,500. So that was the policy rationale for that. Moving along to the next component of the bill, it turns trafficking into a felony. Right now, firearms trafficking is a misdemeanor. Most of these cases are prosecuted under the federal law, mainly because, well, it's a resource allocation thing, but also because there are stiffer penalties in the federal arena. So if you're trafficking firearms, that's what that does there. The next one is does not apply to a firearm. That's the same. It's then the rest of the part goes on to the gun buyback regime that I described at the top of the presentation. And so with that, Mr. Chairman, that is the bill. Ask for a favorable report, and I'll stand by for questions.
Thank you, Mr. Chair. Can you walk us through thanks for being here. Thanks for the bill. Can you walk us through the gun buyback portion where you elaborated about how it changes, which parts of the gun the buyback applies to? And did I hear it correctly that the buyback would only be applicable if you turned in 100% of the firearm?
So right now, if you operate a gun buyback, and there have been several, there's one coming up in Montgomery County next month. You have to collaborate. Usually what happens, it's a church or a nonprofit entity that teams up with an FFL or a law enforcement agency, because you have to be a law enforcement agency or an FFL to receive that firearm. So they will team up, and then what will happen is that they'll go ahead, and what's happening, I can tell you in Montgomery County, is that they are then incinerating those firearms. What this does, it just says, it kind of makes a unified standard of how you have to dispose, that you have to obliterate them, not how, but that you have to, if you receive them. It does make an exclusion work in conjunction with MSP, or the Maryland State Police, to ensure that if there are firearms related to a criminal investigation, right, that those are preserved, that you don't have to destroy those, because obviously every time they receive a firearm, they're going to run that NCIC check, that National Crime Information Center check, to see if it is a crime gun, to do that trace data. So that's the basic process that this sets up. There was no opposition to this bill because I think law enforcement agencies want to do this. They also said, hey, look, why don't you, while you're at it, let's make it that you have to do this within 6 months of actually receiving the firearm. So we worked extensively with them to suss out the language.
The Public Safety 5902, which says the section does not apply to a firearm if a law enforcement agency determines that the firearm is stolen or is evidence of a crime. What does that apply to? I'm trying to bring it up now. Can you elaborate about that?
No, that's exactly what I was just talking about. That's the piece where if they receive a crime gun, so what they do is, what these buybacks say is, like, you turn in your firearm and there are no questions asked.
Yes.
But they do run that NCIC check.
Yes.
And so if they find that it is a firearm suspected to be connected to a crime, they can this creates that exclusion. They
don't have to obliterate. They
Correct.
can retain it for investigatory
right.
purposes.
Correct.
Okay. All right. Thank you.
Thank you, Mr. Chair. Good afternoon, Senator.
Good afternoon.
So I guess I have questions just on the gun felonies aspect of your bill.
Yeah.
One, I guess first question is about the vehicle, because obviously you've cross-filed the Kingpin bill that has the other gun felonies on it. And we actually took the trafficking felony that you sent over on that bill last year and made it a part of the bill as introduced this year before we sent it over. So I just wanted to flag we now have 2 vehicles with gun felonies on them. The other one I would flag for you is we seemingly thought we took care of the problem with on the gun theft with last year's version of the bill, which just made the possession a felony. So I guess are you thinking these are complementary, competing, or do you have a specific reason for one? Because you have to catch them in the theft, I guess, versus the possession. So
It is,
what's
look,
the
you
rationale?
can't steal something without possessing it. And it is much more difficult to catch someone stealing it than possessing it. If possession of, and so possession of a stolen
You can
firearm.
possess it without stealing it, but you
Correct.
can steal it. You can't steal it without possessing it.
So but there is no anti-merger provision in this bill. So conceivably, you could, if you were caught stealing, that would
Get
merge.
2 felonies.
No, I'm sorry. It would probably merge. I asked counsel this. It would merge, and so you would get the higher felony, even though you would get the felony, not the misdemeanor. They're both 5 years. Do you understand? Is that because possession of a stolen firearm is a 5-year misdemeanor?
Okay.
And so if you got caught stealing, it would merge into that. Possession and theft would merge, and you'd get the felony.
I mean, look, yeah, no, the chair's making faces too. So I guess I'll ask the question again. Do you not feel we sufficiently addressed this issue with the way we did it in the Kingpin bill?
Because you created possession.
We made possession a felony along with the rest of the ghost obliterate.
Ways to do it. They're both the same result.
Okay. Okay. Well,
You're
I guess
gonna have
we
the same
have
result.
each other's bills now. So
Yeah.
We can work
You
on
have the same
Yep.
result.
Great, thanks.
2 ways to get to the same result.
Thank you, Mr. Chair. I have to ask this. So the FOP has been really up in arms about what they perceive was their promised protections for carry rights last year.
That's
And
right.
it seems to be a technical fix. It's in one place, but not the other. And being that there's a provision in this bill to kind of clean up last year's language, I wanted to inquire with you. There's evidently some things happening in the Senate trying to fix this, or would this be a good spot to maybe fix that problem
So
as
the plot
well?
thickens. Here we go. We are looking, so I have the cross file of Delegate Moon's bill. And we are looking to move a version or the version
Which bill?
Of the Kingpin bill, which I don't know how that passed out of here. So I have the cross file. And so in this 11th hour of session, we are going to use my version of that bill as the vehicle for that fix.
So you're going to fix this issue for the FOP?
And then move Delegate Moon's bill.
Thank you, Mr. Chair.
In tandem. Are you all following that? No. I'm stripping that bill.
All right, we're gonna get on this bill
Yeah.
now, I think.
It's all working together. It's like whole,
Are there any more questions on this bill? Shall we, just curious? All right, seeing no further questions. Thank you very much, Senator Smith.
Thank you very much, Mr. Chairman.
That concludes Senate Bill 1097. Thank you, Mr. Chairman. Appreciate it. We're gonna go now to Senator Quarterman's. I'll let members of the committee know, my intention after this bill is to recess until 4, and I think we'll just go straight into the voting session. It's a little bit later, and I think people are gonna want to get moving. So we'll go with Senator Quarterman and Senate Bill 849, please.
Great. Thank you so much. Good afternoon, Chair Clippinger and members of the Judiciary Committee. For the record, my name is Mary Till Medina, representing Senator Quarterman, District 2, Washington, and Frederick counties. Thanks for the opportunity this afternoon. I am presenting SB 849, Local Government Tort Claims Act for the Hagerstown Multi-Use Sports and Events Facility. So this bill simply adds the Hagerstown Multi-Use Sports and Event Facility in Washington County to the local government definition under the Local Government Tort Claims Act. To provide a little bit more context, in 2021, the Maryland General Assembly authorized the financing and construction of this facility, which in May of this year will become home to the Hagerstown Flying Boxcars with the Atlantic League of Professional Baseball. The Hagerstown Flying Boxcars. It's pretty awesome, actually. Yes. That's a good point. It's going to be a good time. So the fiscal note did raise some questions on the ownership of the facility. And so it appears the bill drafter had reached out to the city of Hagerstown and Washington County to obtain some documentation that actually shows who will be owning the facility, because it will not be owned by the city or county. And this is where it gets a little interesting, because all of the other minor league stadiums in Maryland, so think Frederick, Bowie, Salisbury, Aberdeen, they are owned by some sort of government. So this Hagerstown facility is unique in the fact that while the state of Maryland is constructing it by way of the Maryland Stadium Authority, once completed, it will actually be handed over to a local nonprofit that will own and operate the facility. So that's where this bill comes in. So while the state isn't the official owner, they will be paying the debt service. And we just felt that it would be in the best interest of the state to have some of that liability protection in the same way that these other facilities have that protection. So it just creates equity here. And that's what the bill does. So there are no amendments. It passed out of the Senate unanimously, and we ask for a favorable report.
Quite an interesting logo. Delegate Moon.
I think Delegate Tolles beat me to the punch, so.
Oh, thank you. You're such a gentleman. Thank you. Thank you. Thank you, Mr. Chair. So I have just a quick question. So I know we have one in Prince George's County and Delegate Taylor's district, and I wanted to know what happens, as you indicated, they are owned by some government entity. For example, in Prince George's, our park and recreation owns our park, our minor league baseball.
Mm-hmm.
What happens if this nonprofit does not survive, goes under, and there has been state investment into this facility, and no other facility has, that protection of the government? Is not the same with the, as a nonprofit, they come and go.
Mm-hmm. Sure.
So.
That's a fantastic question. I would love to follow up with you offline about that. I'd have to do some more research because I'm honestly not sure.
Sure,
But-
that'd be great. And then who the nonprofit is.
Absolutely.
Okay,
Mhm.
thank you,
Mhm.
Mr. Chair.
All right. Seeing no further questions, I don't think. That will conclude the testimony for Senate Bill 849.
Thank
You
you.
very much.
Mhm.
Members of the committee, we will be back here, let's say 4 o'clock. 8 minutes, take a little bit more than a little bit less than a 10-minute break. We'll come back for a voting session